So just to sum everything up, so the pretrial summary, so after someone is arrested, they get booked into jail, and prosecutors create a criminal complaint, which essentially outlines the charges that a person is charged with. So after a criminal complaint is filed, generally people are entitled to an arraignment within 24 to 48 hours, and that is where they go in front of the judge, and three things happen. One, the defendant is made aware of the charges listed in the criminal complaint. It allows the defendant to enter a plea for each of the charges, or each of the crimes they are charged with, and then it also provides an opportunity for the judge to determine the appropriate bail, either to hold the person or let them go. And then after that, we have so if a person says that they are not guilty, then it goes to a preliminary hearing where prosecutors essentially are trying to convince a judge that there is enough evidence here, establishing probable cause for the charges, or the crimes that are being charged. And it's really to convince the judge whether or not probable cause exists. And so if probable cause exists, the judge agrees that this is a case that is worthy of dealing with. And all this time is when a plea bargain can happen. So they can go all the way up until the start of a criminal trial. And if a prosecutor wants to offer a plea bargain, that can definitely happen. If a person says that they are not guilty, they go through the preliminary hearing where the judge establishes that there are probable cause for these charges. And so if they are going to go to trial, the next thing that happens is the jury selection process, and that is called the voir dire, and that is the vetting process where prosecutors and defense attorneys are asking prospective jurors questions to identify if there is any bias in particular cases. And so they're essentially picking people that they want to be on the jury that they believe that can be unbiased, yet are also kind of sympathetic to their side, whether they're on the side of the prosecutor or defense. So once the jury is set, it goes to the actual criminal trial. That begins with the opening statements, which are essentially the roadmap to the case that the prosecutor or defense attorney is going to present. Prosecutors are going to give kind of a brief overview of the evidence and a summary as to why the jury should find the defendant guilty beyond a reasonable doubt. The defense is going to go up and say, everything the prosecutor is going to tell you, you shouldn't believe. It wasn't my client, it was someone else. All the witnesses that they are going to bring are not reliable, yada, yada, yada. Please find the defendant not guilty. So then it goes to the prosecutor's case in chief. They are able to bring in any of their witnesses. The defense is allowed to cross-examine the witness. After the prosecution is done bringing in all their witnesses, they rest their case, and then it turns over to the defense to present their case in chief. Again, they can call witnesses. Prosecutors can cross-examine their witnesses in order to kind of impeach their credibility. And it goes back and forth until the defense is done with all of their calling all their witnesses. Then the defense rests. Then it can go back to a rebuttal where the prosecution can call either new witnesses or witnesses that have already testified in order to clear up anything that the defense brought up that could potentially impact the jury. So the defense may have poked holes in the prosecutor's case, and so prosecutor is going to be like, we should probably bring back in the pathologist so he can kind of explain, the reality of the defendant's arguments, or this makes our case look weak, so let's call in a couple of these people to help kind of clarify what that person was thinking or saying. The defense is trying to get you to believe that didn't happen, or blah, blah, blah. And so then the defense can, again, come back and call their witnesses and argue, and this essentially goes back and forth until both sides are satisfied. And then it is closing statements, which is each side's kind of final opportunity to convince a jury of their perspective of the case. It begins with prosecutors. Defense attorneys then provide their closing arguments, and then because prosecutors have the burden of proof, they are the last ones to kind of wrap everything up. The judge gives juries instructions about what they're supposed to do. Juries deliberate, and then they come back and provide a verdict. Whatever that verdict is, if it is guilty, then it goes on to the sentencing phase, where victim impact statements are read, and juries and judges essentially decide what the punishment should be. If it is a capital case, you have a jury that is deciding whether or not the person should get life in prison without parole or the death penalty. And that is the anatomy of a criminal trial.